Right, it looks like we are live on YouTube. So good afternoon, everybody, and welcome to the final round of the 2021 Southwestern Law School Moot Court Intramural Competition. On behalf of the Moot Court Honors Program, I would like to thank all of our competitors, judges, and members who made this competition such a success. Today, we have the honor of our final bench consisting of 4 state Supreme Court justices: Justice Goodwin Liu of California, Justice Sabrina McKenna of Hawaii, Justice Abby Silver of Nevada, and Justice Reeves Kistler of Oregon, who will be acting as our Chief Justice today. Good luck to our competitors, and without further ado, I'm going to go ahead and call our case. Oyez, oyez, oyez. California Court of Appeal is now in session. Justice Kistler presiding, along with Associate Justices Liu, McKenna, and Silver. All persons having business before this honorable court are admonished to draw near and give their attention, for they shall be heard. God save the United States of America and this honorable court. The first case for argument today is Michael Earl versus Bellstar. Thelma and Baysway Daniel for appellant and Andrew Lutfala for respondent.
Good afternoon. We'll now hear argument from the appellant when the appellant's ready.
Good afternoon, Chief Justice Kistler, Associate Justices, and may it please the court. My name is Thelma and Baysway Daniel, on behalf of the petitioner, Michael Earl. Your honors, in a civilized society, a person is entitled to peace of mind. The case at bar is reviewed de novo. As such, this court should reverse the trial court's incorrect grant of summary judgment because there are triable issues of material fact here for the following 2 reasons. First, the respondent's continuous social media posts amounted to actionable threats. Second, the respondent abused a position of power. I'd like to respectfully request 1 minute for rebuttal.
Granted.
Your honors, continuously targeting a plaintiff and their family to coerce a desired outcome is extreme and outrageous conduct. As stated in Kaczynski versus Carpenter's Trust for Southern California, decided by the Second Appellate District in 1983, the court held that the defendant's threats towards the safety of the plaintiff and his family was sufficiently outrageous. The Kaczynski court also lets us know that behavior is outrageous if 1, the defendant abuses a position or relation that gives them power to damage the plaintiff's interest. 2, knows that the plaintiff is susceptible to injuries through mental distress. Or 3, acts intentionally or unreasonably with the recognition that those acts would likely result in mental distress. The word "or" in between the first 2 clauses and the 3rd clause is an important modifier here because it speaks to the independent nature of each clause. The respondent satisfies at least 2 of those clauses. The word "reasonable" in the 3rd clause means that we look to the facts and circumstances of the case. The facts and circumstances of this case suggest that she did act intentionally and unreasonably with the recognition that her post would likely result in Mr. Earl's mental distress.
So counsel, how do we know that in fact she understood her words would translate into actions by third parties?
Thank you, Your Honor. Yes, she did know, and this is why. As seen on the record on page 53, during her deposition, Ms. Starr admits that she read Mr. Earl's email on page 19 of the record, where he explicitly named that he was suffering, his family was suffering, and he feared for the safety of his wife and his minor daughter. However, the very next day on June 22, as seen on page 19 of the record, she posted again with that knowledge, exposing his minor daughter's name and his home address. For that reason, she had knowledge and she had recognition that her post would likely result in Mr. Earl's continuous suffering.
Counsel, to help, go ahead, please.
Respondent's conduct here is not even close to the extreme and outrageous conduct involved in Jackson versus Mayweather case, which also involved posting on social media the plaintiff's address. But it further commented on plaintiff's abortion or sonogram and a doctor's report. So why did the district court err by granting summary judgment under the facts here?
Your Honor, it did, and this is why. Where reasonable minds differ, as stated in Teco versus the United States of America, decided by the Ninth Circuit in 2007, where reasonable minds differ, it is up to the triers of fact to decide on sufficiently outrageous conduct to support a claim for intentional infliction of emotional distress. The very fact that each counsel is here before the court indicates that reasonable minds indeed differ when it comes to the sufficiently outrageous nature of Ms. Starr's conduct. We're not deciding on the case today, Your Honor. We're just saying that there is enough to at least let the jury decide on the case. There are triable issues of material fact here. Also, Your Honor, as stated in Huntington Life Sciences versus Stop Huntington Animal Cruelty, decided by the 4th Appellate District in 2012. Your Honors, there, in 2005, I'm sorry, Your Honors, there, the respondent and the defendants did not actually make the threats, nor did they have the actionable threats. It was their supporters. The court reasoned that the defendant's conduct, posting the home address of the plaintiff to their website, and particularly encouraging the plaintiffs, encouraging its supporters to protest against the plaintiff, amounted to sufficiently outrageous conduct. Because
counsel, if I may, in this case, the defendant did not post the actual street address, correct? And I'd like to direct your attention to our state Supreme Court's decision in Potter versus Firestone Tire and Rubber Company. And in that case, didn't our Supreme Court say that conduct to be outrageous must be so extreme as to exceed all bounds of that usually tolerated in a civilized community? So how do the facts of this case meet that standard?
Your Honors, you are correct. That is the standard. However, this court strives to be deliberate about each word stated in its judicial precedents. Its inclusion of the word reckless and unreasonable when measuring the state of action for intentional infliction of emotional distress and sufficiently outrageous conduct suggests that instead of that door of liability being shrunk to a doggy door, it is in fact a standard sized door to allow people just like Mr. Earl to walk through and be compensated. And to Your Honor's specific question, her conduct does amount to sufficiently outrageous conduct because this case turns on knowledge. Perhaps we'd be having a different conversation if Ms. Starr read Mr. Earl's email and decided not to post again, but she did. Here, as stated in Huntington, peace of mind is now a legally protected interest, violation of which amounts to its own independent wrong. Here, the respondent indeed violated and disrupted Mr. Earl's legally protected interest to peace of mind, which brings me
counsel. If I can stop you for a second to ask you a little bit about Huntington. My memory of Huntington is that in that case, there was a history of posting by the HLSLAC or whatever it was that was trying to stop Huntington. And they actually had targeted people in the past, which gave them knowledge that their post would have an effect. Is there something comparable here that would show that Starr knew that her post would cause her followers to act in the way that they did, or whomever acted?
Your Honor, yes, there is in fact something, and this is why. As stated on page 52 and 54 of the record, the defendant herself, the respondent herself, stated that she wanted her fans to rise up on her behalf and that she knew her fans would be angry. She also said that she was not surprised that they sent hate mail and different things towards his home and his work. And for that reason, it does amount to sufficiently outrageous conduct. Also, Your Honors, as we usher into this newer era of social media, this is a ripe opportunity to deter sufficiently outrageous conduct, just like Ms. Starr's. Additionally, Ms. Starr is in a position of power. She has 224 million followers, as seen on the record on page 7 and page 8.
But counsel,
That's right,
you have
Dan.
144 million followers, and the record shows that there's some decals on a car, 27 hate letters at home, 42 hate letters at work, a rock, a crank call, and a handful of maybe some more letters. I mean, in the big scheme of things, how is that sufficiently outrageous considering it's 144 million followers?
Your Honor, I respectfully disagree. She actually has 224 million followers. If you put together France, Australia, and Mexico, that population would still be 4 million short of the defendant's following. If defendant following was a country today, it would be the 5th largest country in the world. No one can attest that someone like LeBron James does not have enough power over the CEO of the Lakers. For that reason, she is in a position to damage the plaintiff's interest, and she did in fact do so. As seen in Young Hee So versus Sukjak Sin, decided by the 2nd Appellate District in 2013. There, the court reasoned that the anesthesiologist's unequivocal knowledge of the plaintiff's vulnerability following a miscarriage amounted to sufficiently outrageous conduct. Again, in Bundren versus Superior Court of California, decided—
Daniel, could I interrupt you? I just want to go to your point about social media, because I think that is an interesting dimension of this case. Not everyone's going to have as many followers, but when we're applying the legal standard to a situation where social media is involved, is it always going to be the case that a person who is of a reasonable, who has a reasonable size following will always be, I guess, vulnerable then to this kind of suit? Because who knows what, forget about 200 million or whatever the figure is. Well short of that, you already have significant problems of third-party action, whether it's 200,000, 20,000, or even 2,000. So can you give us some guidance about how we're supposed to apply these standards in the social media age?
Absolutely, Your Honor. You are correct. It is important for us to be careful because, again, there's no such thing as always when it comes to this particular doctrine, intentional infliction of emotional distress, because we look to the facts and circumstances of the case. And the facts and circumstances of this case here suggest that it is sufficiently analogous to cases where this court's case law and judicial precedent has allowed for tribal issues of material.
Does that mean that anytime someone who has 200 million followers posts something critical of somebody else on social media, that person is essentially opening themselves up to IAED liability on the ground that anybody who has 200 million followers has to know that among that large number of people, there are going to be some unhinged people who will take words and convert them to action. And so that person is effectively on notice that any criticism that they post of any kind could result in some sort of even physical harm to the target of the criticism. Is that where this doctrine leads?
Your Honor, not quite. And let me explain why. The thing that we're having here is this case turns on knowledge. Let's take your hypothetical. If that person indeed knew and had recognition that their acts would likely result in mental distress, then yes, they are open for liability. And is supported by Plotnick versus Niehaus Jr., decided by the 4th Appellate District in 2012. There, the court leaned on the Kaczynski Court's reasoning in stating that subjecting another to mental distress, whether or not those acts result in technical assault or would be assumed as technical assault, is still sufficient to support a claim for intentional infliction of emotional distress. Further, Your Honor, sustaining summary judgment today could have a chilling effect on the rest of the nation because summary judgment is only granted where there is no fact whatsoever to be heard by the jury. Also, the judicial hierarchy that Americans have faith in is that when trial courts err, your honors have the oversight. Your honors have the jurisdiction.
Counsel, knowledge, you mentioned knowledge. What role does knowledge play in this doctrine? Are we supposed to evaluate outrageous conduct according to an objective standard, or what the speaker subjectively intended?
Your Honor, thank you. Yes, knowledge plays a significant fact here because this case turned, I see my time is up. May I briefly conclude and answer your question?
You may.
Thank you. Knowledge is what this case turns on. If Ms. Starr did not post that third time, perhaps we'd be having a different conversation. But as stated in the record, she read his email, knew he was suffering, and subjected him to continuous mental distress. And for that reason, we should at least let the jury hear this case because it's sufficiently analogous to enough cases like Huntington, Koserski, and Plotnick. Thank you.
Thank you, counsel. Respondent.
Good afternoon, Chief Justice Kistler, Associate Justices. May it please the court, my name is Andrew Litfalla, and on behalf of the respondent, Belle Starr, I ask that this court affirm the order granting summary judgment because there are no tribal issues of fact regarding whether Ms. Starr's conduct was outrageous.
Counsel, I'm going to dive right in. Could you just pick up where your friend on the other side left off? What is the role of knowledge in this doctrine?
Thank you, Your Honor. Outrageous conduct is conduct that is so extreme as to exceed all bounds of what is usually tolerable in society. Although there is no bright line standard, it is an objective standard, and the courts will look to each individual case and the facts and circumstances to determine whether the conduct is outrageous. In this case, after Mr. Earle's childlike treatment of Ms. Starr, she behaved childishly when she vented her frustrations on social media. But childish behavior is not extreme and outrageous conduct.
So counsel, let me interrupt for a second. If you assume for a moment that the first post is permissible because no one had acted in response to Ms. Starr's post, after they put the stickers on the car, why isn't Ms. Starr at least charged with sufficient knowledge that her words will affect people in a way that would make further criticism reckless?
Thank you.
And in essence, that the social media is magnifying her unhappiness in ways that if she just spoke directly might not be actionable, but acted through other people might be. Long question, so I apologize.
I'm happy to answer, Your Honor. Regarding Ms. Starr's language that she used, such knowledge of what may have occurred as a result of her language is not actionable unless she takes some directly harmful act in association with that type of language. When she posted Mr. Earle's private information, including the name of his daughter, his home address, the make and model of his car, the address of his office, although disclosing such information during this dispute may have been a childish act, that disclosure information alone, even in the anticipation that she might stir any of her followers to commit any type of action against Mr. Earle, is not sufficient to be actionable.
So how do you reconcile, pardon me, one fast question. How do you reconcile that with Huntington?
Yes, Your Honor. In Huntington Life Sciences versus Stop Huntington Animal Cruelty USA, 2005, the California Court of Appeals found that SHAC USA's endorsement on its website, explicit endorsement of the Animal Liberation Front, which is an organization known to commit acts of trespassing and destruction of property in conjunction with its advocacy of animal rights. SHAC USA endorsed the use of illegal acts explicitly on its website, and as such, the court found that its conduct was outrageous. However, in this case, Ms. Starr never once explicitly directed her fans or encouraged her fans to take any such illegal actions toward Mr. Earle in any of her social media posts.
Ms. Counsel, aren't the facts so in this case much more in line with Kirksey versus Carpenters Trade Union for Southern California? Because respondents' words here were veiled threats which rise to the level of outrageous conduct intended directly to inflict emotional distress?
No, Your Honor. Although the veiled threats that were made in Kostesky versus Carpenter's Southern California Trust were veiled threats, the language used was graphic language, wherein the union members stated that they would kill the person's family or kill his children, and they threatened his own life as well. However, Ms. Starr never used such graphic language. And this case is also distinguishable from the case of Plotnick versus Mayhouse, 2012, where the neighbor's sons threatened to kill the neighbor's dog and threatened to injure his wife as well. The language Ms. Starr uses is unclear and does not rise to the level of an actionable threat. This case is more analogous to the case of Cochran versus Cochran in 1998, where Mr. Johnny Cochran left a voicemail message on his son's answering machine, threatening to give his daughter-in-law the Value Jet Around the World package, which the court in that case considered to be a vague threat because the language's meaning was hidden and it lacked immediacy. Here, similarly,
I'm sorry, if I may ask a question. Is it your position then that a civilized society should tolerate a person with such a great following with knowledge that a previous post had resulted in threats to the family, to allow such a person to post the address, name the minor daughter, and also mention the pitiful security system within the person's home? Why should those types of statements be tolerated in a civilized society?
Yes, Your Honor. Regarding why Ms. Starr's statements should be tolerated, in our social media age, such statements as Ms. Starr's, although in this case might be more frustrating to Mr. Earl, are commonplace on social media. And the venting and childish manner in which Ms. Starr expressed her frustrations with Mr. Earl over their dispute does not rise to the level of extreme and outrageous conduct that has been set by this court in precedent cases. As the court in Cochran versus Cochran stated, the tort of intentional infliction of emotional distress was never meant to intervene whenever someone's feelings were hurt. It was never meant to remove all such barbs. There is a necessary amount of steam that the parties must be allowed to vent, and parties must also be expected to endure some rough language in the course of these feuds. Here before us is a feud between parties over the direction of Ms. Starr's career. She expressed her frustrations ineloquently and childishly on social media, but this is not rise to the level of actionable.
I think that covers some of the conduct that your client engaged in, but what could possibly have been the reason for disclosing the name of the plaintiff's minor daughter or the residential street on which she lived?
Yes, Your Honor. According to Ms. Starr's deposition, she wanted to inform her fans that Mr. Earl had achieved so much of his success and wealth due to Ms. Starr's hard work. In a prior letter that Mr. Earl had sent to her, record at 15, Mr. Earl had stated to her, "Remember the old adage, don't bite the hand that feeds you." The language she used was part of a larger dialogue that Ms. Starr was having publicly about her position in Mr. Earl's life and this threatening.
That's what she testified, right?
Yes, the record at 52.
Why must we believe her?
Your Honor, regarding whether or not her intentions were to direct her fans or to speak out against the harassment and bullying that she received, even if this court were not to believe Ms. Starr at her face, the facts alone on their face indicate that her conduct does not reach to the level of outrageous or actionable conduct, because she did not explicitly threaten or direct her fans or encourage them to take any actions. And the language, even in posting the private information of Mr. Earl or his family, does not amount to that. And regarding—
Counsel,
yeah.
This is probably an unfair question, but are you familiar with Henry II, who asked, "Who will rid me of this meddlesome priest?"
No,
and later Thomas Becket is killed in the cathedral. It was kind of an indirect request that had an effect? Could a jury infer that this was the same kind of indirect request that she was directing her fans to set upon Mr. Earl?
Yes, Your Honor, a jury might be able to infer such conduct. However, the facts alone do not indicate such and do not meet that rigorous and difficult to satisfy requirement that this court has set for these elements of intentional infliction of emotional distress. Now, regarding Ms. Starr's position of power over Mr. Earl, her social media fame and celebrity does not amount to a position of power. And in precedent cases, this court has chosen not to look at social media fame or celebrity status as a position of power relationship for specific policy reasons. To do so would broaden the definition to such a degree that it could have a chilling effect on the ability of people such as Ms. Starr, potentially young artists in positions like her, from speaking out in fear that men like Mr. Earl might be able to use the tort of intentional infliction of emotional distress as a sword to cut these types of moments of speaking truth to experiences such as Ms. Starr's from happening, or to chill others who would speak out like Ms. Starr from doing so.
Counsel, getting back to Justice Liu's question and my previous question, why name the minor daughter? What purpose could that serve? Why is that not outrageous?
Yes, Your Honor. Ms. Starr felt treated like a child by Mr. Earl. In prior record, she had some type of relationship with his daughter, Lenore. It is not too difficult or not too far for this court to construe that when Ms. Starr acted ineloquently and childishly by posting her name, she was not doing so with the intent to harm Miss Lenore, but as a matter of sympathy with Lenore over her own treatment by Mr. Earl. Although it was, albeit an unfortunate thing for her to post Miss Lenore's name on social media, such action alone is not actionable conduct.
The counsel, didn't she also, along with posting the child's name, describe the type of vehicle he drove as well? And again, gave the home address, the business address. When you take it all together, couldn't this get past summary judgment as a matter of law as being outrageous conduct under these particular facts?
I respectfully disagree, Your Honor. Based on the language she used, it really does not amount more to the venting of frustrations in a feud that elevated to a place where she felt the need to publicly disclose it. And this goes back to the argument concerning position of power. Mr. Earl is the chief executive officer of Big Shot Records. She is contracted to them as an artist, and he has the power to directly affect her interests and to control the direction of her musical career. She chose to speak out publicly and use the platform afforded to her that would otherwise not have been afforded to her in years past. Social media gave her an ability to speak out in justice and call out what she believed to be bullying, harassing, and threatening language, record at 17. When faced with these types of situations, we should protect the interests of artists like Ms. Starr, despite the amount of followers they may have. Because as Justice Liu stated previously, regardless of whether someone has 200, 2,000, 200,000, or 200 million followers, they are all people with the ability to speak out on their own behalf, and it should be afforded the freedom to do so without worrying about this tort being used as a sword against them.
So would the only limit that you would pose on anyone speaking out be an explicit threat made on the internet? Can it be implicit?
Yes, Your Honor. I would argue that explicit threats would be actionable and implicit language would be actionable if accompanied by directly harmful acts taken directly by the plaintiff.
So it has to be the plaintiff who takes the action, not the followers of the plaintiff who take the action?
Yes,
In other words,
yes, Your Honor, because to allow otherwise would create undue liability because every person who'd post on social media would be expected to be held accountable for the actions of followers who are associated or attributed to them, or if their posts reach far beyond their follower base, to any person who has privy or has the ability to have read said posts. That type of liability is too expansive and is too uncertain in this day and age where social media has come to dominate our public discourse. As such, Ms. Starr's conduct and her position of power should not be considered, her position as a celebrity status should not be considered a position of power, because to do so would create this chilling effect on people like Ms. Starr. The power of social media to allow people like Ms. Starr a platform is a significant power. However, regardless of her follower base, a woman who was in Ms. Starr's position, who say had 500 or 10 followers, and whose message would reach others, should not be expected to be held liable if, say, their message goes viral and reaches millions of people in an employer-employee context that's akin to Ms. Starr's today. That is why I asked this court to affirm the order granting summary judgment, because the conduct that Ms. Starr took was childish, but does not reach that rigorous and difficult to satisfy requirement of extreme and outrageous conduct. So I ask this court to affirm the order granting summary judgment. Thank you, Your Honors.
Thank you, counsel. Rebuttal.
May it please the court. Your Honors, I'd like to first start with addressing Justice McKenna's question the respondent failed to address. Why name the minor daughter? Why name the minor daughter? She did this because she wanted her fans to rise up on her behalf. As stated on page 17 of the record, she said that she will not stop until she gets what she wants. She also stated in page 7 and 8 of the record that she wanted her fans to let this jerk know what they think of him. That is an incitement. As well, Your Honors, for the respondent to mischaracterize Cochran versus Cochran, decided by the Second Appellate District in 1998, there was an intimate relationship between a man and his ex-wife. That is very different from what we have here. They have a personal, this is a business relationship. Respondent cannot have it both ways. And to reduce Ms. Starr's conduct to childish is actually a little insulting, because it could have a chilling effect for people. If she's 22 years old, I see my time is up. May I briefly conclude?
Yeah, but keep it short.
Your Honors, there are tribal issues of material fact here. This is distinguishable from Cochran, where there were no actionable threats and there was one single voice message. And for that reason, we should at least let the jury hear the case. Thank you so much.
Counsel, thank you for your arguments. We will now be in recess where we will decide who wins and who loses, and we will come back with our decision as soon as we can. Thank you very much for both of you.
Thank you all very much. To our live stream, we will be back shortly. The judges will be moved to another room to deliberate, and as soon as that deliberation is concluded,
Competitors, you can turn your cameras off while we await the results. Thank you.
All right, Justice Kistler, we are live.
Okay, great, thank you. And my understanding is we're back live stream. And there's always a question about order, which is it better to announce who wins first and then give our thanks to both the contestants and to the Southwestern, or is it better to thank Southwestern and keep everyone in suspense? So my preference is going to say first who wins, and then we'll want to express our appreciation, our gratitude to Southwestern. As with every time that I've had the pleasure of judging this competition, it has always been incredibly close. And it's very, very difficult to pick one person over the other. And it's also incredibly difficult to remember that you're first year law students. You are far too good, you're far too calm, you're far too polished to be first year law students. What people typically say, and it in fact is true, is, we would be happy to have you arguing a case our court. You would do a wonderful job and you would help the court decide the case in the appropriate way. So with that sort of preface, let me tell you that although it is a very difficult decision, that we decided that the appellant had the better of the argument, and not on the merits, but in terms of the argument. So congratulations. Yes. So I'm so pleased for you. That's it for both of you. Anyway, so let me both say, and I'm going to open this up for anybody else after I finish, and hopefully we'll keep it relatively short, to tell you again how much we appreciate being here. Southwestern has always had one of the strengths I think of Southwestern is the community of students, the community of the professors, and just being in Southwestern and hearing the arguments. It's been harder this year for us, and I assume for you, because everything has been remote. But the same spirit that it seems to have animated Southwestern for the years that I've been able to come here is still here. You should feel very fortunate to be here. We're fortunate to have students like you becoming members of the bar. I would be remiss if I didn't thank Professor Carpenter and Professor D'Italia. And if I was reading the question right, I don't think Professor Turner wrote it this year. It's a different professor, but it was a wonderful problem. It's a fascinating issue as to how social media works and how criticism can get magnified by the followers of people and who's accountable when they act out in ways that perhaps may or may not have been foreseeable. But it is such a pleasure to be here, even remotely, and to hear you argue. So thank you so much. And with that, I will invite the other people who are on the panel with me to say anything that they want to or not.
I'm happy to add a word. Congratulations to both of you for extremely fine argument. I echo what Chief Justice Kistler has said. It's really a pleasure to hear such talented argument, and it is true, actually, that you fare well compared to attorneys that are years your senior who have argued in our court. So you have very, very bright futures ahead of you. I'll just say that I think that the facts that you were given are an interesting problem. And for an appellate court, you might adopt the frame of mind of trying to think about the appellate court is trying to set a rule. And of course, in this kind of problem, it's very hard to set rules because it's such a fact-bound set of issues. Ms. Mbezwe and Daniel, your position, I think, is, in my view, somewhat favored by the facts because there are a lot of good facts for you. But your problem, I think, is that you need to, the problem, not yours, but the problem for your side is that you need to articulate some sort of limit, right, as to why it is that not every set of facts is going to go to a jury. And that's going to be pretty hard in the social media age if you allow one set of facts to go, and the next time somebody, it doesn't have to be a celebrity, but somebody says something and then it incites another person to do something crazy. This is where it sort of leads. And so courts would understandably, I think, be very wary of opening up that door, even though the facts, I think, favor your result in this particular case. So that's kind of, I'm just giving you a sense of what appellate judges might think about. And then conversely, I think for Mr. Lafala, it's just the same problem in reverse, which is, what additional facts would be needed to have pushed this one over the line from your point of view. We pressed you a little bit on the naming of the street and the daughter. Those are pretty bad facts for you. And, I'm not exactly sure what you can do about those facts, except to say, these may be bad facts, Judge, but, sometimes the law, that's where the rule of law has bite. It is a rule of law because even when there are bad facts, the rule must apply. If we simply tailored the law, to every factual scenario that we thought would come out with the correct or just or fair result, that's not a rule of law. That's just a rule of intuition. And then, you could have proceeded something like that. In any event, I just give you that as a flavor for the kinds of real life problems that appellate courts actually have to deal with. And if you're, thinking not just about your particular case, but you're trying to help the court, be an aid to the court. That's why you're called officers of the court. You're trying to help the court figure out a sensible rule for a difficult problem that has other permutations down the road. But congratulations to both of you. Really wonderful argument. I'm pleased to have been part of it.
All right, I'll jump in here, and I'm just going to agree with Justice Kistler and Justice Liu. Both of you were excellent. It's amazing that you are just 1Ls. I agree with Justice Liu that I thought the facts favored the appellant here. And it was, to me, it was a tough case for the appellee. But also, and I don't know if you were able to make this type of argument because I think you were restricted to the record, but it seemed to me with respect to the name of the minor and the street, the reality is in this day and age, that information was probably ascertainable by anyone who wanted that information anyway through other public sources. Perhaps that's an argument that maybe you couldn't make, but I commend both of you. You were both excellent. Thank you. And now the Southwestern Law graduate, Justice Silver.
Thank you. What a pleasure to be here today, to watch you two argue. Your preparation and your polished arguments, I mean, it really shines through. You are both amazing advocates for your side. And I just can't tell you, again, what a pleasure on a Saturday to sit here and be a part of this. So thank you so much. And I agree with everything the justices have said. I think the most astonishing thing for me is actually to watch you two, and I cannot believe you're both first-year law students with how good you come across, both of you. I thought you did a great job. It was a very difficult thing for us to decide. Both of you did great. Who did better? The respondent had some really great arguments, and I know you answered, I wrote down great answer after you answered something for Justice McKenna about these are mere insults and it's just a childish feud and conduct. And you really knew the law and you knew the record. And I can't commend you enough. And then I just loved when the appellant started her rebuttal, where she just that's my old prosecutor, just come right back in and like a hammer. And you just really nailed that rebuttal. And so, again, my hat is off to both of you. You did excellent, excellent jobs, and congratulations to both of you. You should both be extremely proud of what you've done.
Thank you so much to all of our justices today. Big congratulations to both of our competitors. Congratulations, Thelma. I want to again thank everybody who made this competition possible. Our directors, Professor Carpenter, Professor D'Italia, our laws professors, our moot court entire program, our board. None of this would have been possible without everybody's time and effort. And so I'm incredibly grateful and thank you all so much. I wanted to send out a quick reminder to everyone, all of our notable oralists, quarterfinalists, semifinalists, and of course our finalists and our brief finalists are invited to our banquet, our intramural banquet at 5 p.m. this evening. We look forward to seeing you all there where you will be recognized for your achievements. So thank you all again, and I hope you all have a great rest of your evening.
Thank you.
Do the justices stay on or